This FM 104.3. Good to meet you.
I saw it. And it was signed by Honorable Felix Kwachofosu.
Yeah.
And now someone walking in and say, Omampani Ashe, a year consultation process be Ase. Which consultation process is in respect of the removal of a Chief Justice. Intimi hu krata nam say, "Hey, I dey asem na ebe." Nam say, "Okay." Then my main first wants na me hu what is happening. Only for me to find out that yes, as the president said, there have been 3 petitions. And petition, no, me hunu petition e be. But because it is not in the public domain, and because it cannot also be discussed in the public, the proceedings of the removal of a Chief Justice will have to be done in camera. And so I will hold on with the reasons for the removal of the Chief Justice. But, Minya, my mention wa adwene nyina bibi so. Your constitution no ebo ye ho bra no since 1992 constitution no yaji tu mu se afanya adwuma no. Enye bibia every day yedi buman no ani atro e wo constitution nim. Potokasem no, there is a letter, or if like there is a letter of the constitution. And in instances where black and white yen throw our constitution no, you can also impugn a meaning into it based on the spirit of the constitution. The Supreme Court judge be our being pa so what JSC. Also, so church constitution no more. It is the combined effect of the letter and the spirit of the constitution. And no debate to me the intent of the framers of the constitution. No matter in a paper, ma yinaide yati aseye. In the chapter 7 of the 1902 constitution one. And no, the representation of the people. Electoral Commission. Because what you say, constitution no, how to remove the Electoral Commission from office has not been stated under chapter 7 of the 1902 constitution. It has nothing, whether letter or spirit under articles under chapter 7 of the 1902 constitution to deal with the removal of an electoral commission. Now, you Supreme Court judge see, I'm on my interpreting constitution. I mean, say so. So, ye electoral commissioner, even though you Troy, our constitution, them will be this is article 146 said ye judges no the same way near the electoral commission.
Okay.
It has not been stated in the constitution, but it has been interpreted by way of the letter and the spirit of the constitution. And Ghana, Sir Judge Bia Etnase, na what share mrenim no interpreter, especially the Supreme Court, which is clothed with the interpretative jurisdiction of our constitution. They do so by way of what the Interpretation Act is saying. What is it saying? It says that Ghana, so we interpret the constitution, you interpret it by way of a modern purposive approach. Before we got here, na Ghana, and I say we are fanai. So we interpretation, based on Bibi and Efreno, the mischief rule. It was classically stated in the case of the Hayden. Until law student be an asolo and the Hayden's case, mischief rule. And then in one nearby be a friend the literal rule. Just said Diana the letter and I said Diana on black and white which was stated in the success peerage case. Inti what for book no krata no black and white Diana tro. And you say there are times ube hunu say ya tro de no na emom no said ya tro no say o man no the same meaning sebi edin sunsanso beba omanim and I said this sunsanso beba community nim. So the judges also propounded the golden rule, which was said or stated in the case of the Gray versus Pearson. In the announcement, they are trying to say, "Oh, so the judges will give a meaning, which is the golden rule, which will be different from what has been stated in the Constitution." And the Eddie Muababe drew Samri. A modern purposive interpretation. Now, modern purposive interpretation is there. The trainer say, when you are interpreting the Constitution, do not lose sight of two things, two critical things: the letter and the subject. A dear na dear no, the intent of the framers of the Constitution no person moka. Dear na no person mochre. Enti say akwase boaje me do ko article 146 na constitution no nchen na nka obaboa me ya 146 no eka assembly. And you see the whole of the article 146 no, it deals with two things. What are the two things? How a Supreme Court judge can be removed. Said ye be Supreme Court judge. You see, me can remove the nature say me akra no. I said His Excellency John Dramani Mahama Baye Sinacha Sakwakoya anya fire. I'll fire you. You have been fired. If you have not been fired, your appointment has been terminated. If you have not been terminated, you have been dismissed. If you have not been dismissed, you have been removed. Just no within three months. But 146 no. No ma mienu no. Ba ko ne say ne ye be yi a Supreme Court judge. Ana de tosu mienu. Say ne be yi a Chief Justice. This is the fulcrum in its entirety what Article 146 deals with. Mind you, the Chief Justice is first and foremost a Supreme Court judge. It is obey a Supreme Court judge. Show Constitution Article 1463. Honeka 3 they say if the president receives a petition for the removal of a justice of a superior court other than the Chief Justice, or for the removal of a chairman of a regional tribunal, he shall refer the petition to the Chief Justice, who shall determine whether there is a prima facie case. A prima facie case. Emphasis mine. And the judges now, Supreme Court judges now, which the Chief Justice is one of them.
Mm-hmm.
Say, yeah, the petition be nowhere in the Constitution, especially Article 146, and the how a prima facie case and whom is clothed with the power or jurisdiction to establish a prima facie case against the Chief Justice. In this Ukoyi Puama and as a Bafuboni and as a Colindia Ukoyi sa Supreme Court judges here. President Nina petition no. President no or their petition by Chief Justice, not Chief Justice establishing a prima facie case.
Yeah.
But if it is about the Chief Justice who establishes the prima facie case, because if you come to Article 146(6) it talks about what the president is supposed to do when it comes to the Chief Justice. I was about it. Say, President, any Supreme Court judge petition, no the Chief Justice there, and the Chief Justice there no. it is the president who is supposed to establish the prima facie. Even though I concede that it has not been stated clearly in the Constitution, but the combined effect of the letter and the spirit of the Constitution, and if you want to give it a modern purposive approach of the Constitution, then it is the president who will establish the prima facie. And I'll prove to you why. I'll prove to you why.
Okay.
My whole day no ejina eye 1466.
Okay.
Yen kind 6 no. The 6 says that where the petition is for the removal of the Chief Justice, the President, acting in consultation with the Council of State, shall where the petition is for the removal of the Chief Justice, the President shall, acting in consultation with the Council of State, appoint a committee consisting of 2 justices. In terms of President Jumadi Ediamano, the Jumadi Ediamano one say, so you na address or consult the Council of State, or call say, or appoint a committee, or establish a prima facie case. But what I say?
Yeah.
Or cause or establish a committee. But I am also suggesting to you that before a committee will have to be appointed to investigate the Chief Justice, Constitution under Article 11, Emma President say the President may at any time revoke suspension under this article. That is Article 146 of the Constitution. But what you say? Are you listening to me very well?
Sure.
What that means is that as soon as a president they trigger the consultation process, from how president bet me suspend the Chief Justice. What does the suspension mean? The suspension means that my right or the Chief Justice's right is going to be affected. Anytime that a decision is supposed to be made to affect the right of anybody, please do not lose sight of the basic and the cardinal principle in law when it is about a person's right. And that cardinal basic principle in law is natural justice. And so, si ejutum say a president in a establish a prima facie case in India, any president, because you are going to establish a prima facie case against me, the spirit and the modern purposive approach of interpretation of the Constitution should suggest to you that please listen to my comment, hear my responses. On that basis, it will inform your decision as to whether indeed you are going to now get to the Council of State. It's a Council of State and appointed committee. And that's all appointed crowd. And you see, in the case of Ajechum versus AG and Akwete, that case, you could see the intent of that bar. The intent of that bar was that let me find a way to sieve, or if you like, to prevent unnecessary, frivolous, vexatious petitions. I am Crophobe I call president. Now, call president. Then you can say, the letter of Article 1466, no, just the president, or go consult the Council of State. Normal form your committee, and you better form committees because you can have about 50 petitions that will be given to the president in a month, and they will form committees for all these petitions. So that bar was of the opinion that yes, a prima facie case will have to be established, and it is my understanding that it's a prima facie case in President Bay established here, then we can sieve or we can prevent unnecessary and frivolous petitions that will have to move from the presidency to the Council of State, which will warrant the formation of so many committees. And that is why I am going to court that per my understanding of the Constitution, the Supreme Court should give a true and proper interpretation of Article 1461.
This FM 104.3, Would you mean Taki?